Okay, good afternoon, everyone. Welcome back to Business Law 2. Today we're going to be looking at Chapter 36, which involves estate planning. So we're going to be looking at wills, estates, and trusts. And so in this chapter, some of the overall learning objectives that I'll be focusing in on is understand how both real and personal property can be devised and bequeathed through the process of having a will. Understand what happens to property of a decedent when there is no will. We'll look briefly at what is referred to as testamentary capacity, and that is something that's necessary to, enter into a valid will or to make changes to an otherwise, previously entered into will. The idea of testamentary capacity is similar to just capacity that we covered in Business Law 1, in that you just have to understand the general nature of what it is you're doing in this contract or this agreement. And so when we're applying it to the world of a will, we want to make sure that you understand that what you're entering into, the property that you're devising to whoever you're giving it to, that you understand the ramifications of that and you understand the implications of that. The big concern, I think, with testamentary capacity that comes up is when someone in their later years of life, if they make changes at the last minute prior to death, there's always a question by heirs of, was the decedent in their right state of mind, or did they have the capacity? And we'll talk about that briefly in this chapter. And then we'll get to some of the different types of trusts that exist, and again how estates and trusts kind of interact with each other. So that's going to be the focus for this chapter. The heart of all the topics in this chapter go to what's referred to collectively under the law as estate planning. And so that's the process by which any person decides how they want their assets to be passed on to others upon their death. And so there's generally 4 tools available when you're formulating an estate planning strategy. And you can do this independently. You don't have to have the advice of an attorney, but I do recommend that if you are contemplating a will, most attorneys charge a couple $100, and for the peace of mind that a properly drafted and executed will provides, I think it's really important to kind of, it's a good investment. You can go, find a will online and do it yourself, but if you don't adhere to the formalities, because different states have different requirements, if it's not executed correctly, then it'll be as if you did not have a will. And I'm of the opinion that each one of us, we work hard in our lives for what we have. And if you have a particular wish that you would like something to go to a particular person or organization or entity, whatever it is, I'm definitely of the opinion that I want to make sure that is your last wishes are honored. And so it's important, even though it's not something people like to talk about, but it is important to get this properly taken care of. So wills, that's a declaration of your wishes about disposition of assets upon death. Trusts, that usually concerns when legal title to certain property is held by a person while another has use and benefit of it. So trust can be applied, in a setting where it's like after someone's death. So property can be kind of built or put into a trust. You can also create a trust while you're alive, and so you can dump all of your property into it, and there are certain tax advantages that can kind of run with that. And as you need to withdraw property out of the trust for, let's say, your monthly expenses, then that can become a taxable event at that point. But there are certain strategic advantages, not just upon death, for the use of trusts. Gifts, that's a voluntary transfer of property without consideration. So if you recall when we talked about different types of gifting in Business Law 1, if you remember, there was that one type in causa mortis, which is in contemplation of death, versus inter vivos, which is between living entities. So gifting can happen at any point, during your life or near the end or at the end of your life. And then some other issues that arise is joint ownership. Sometimes referred to as like joint tenancy or tenancy by the entirety, where property can possibly revert to a surviving person who's titled on a particular, whether it's real or personal property. And then there would be kind of like no need to kind of go through a will process. And we'll talk about that as well. Anyway, so wills, it's a written thing that provides for disposition of property, and it takes effect upon the death of that person. Unlike a contract, a will is not binding as long as the person that makes it is living. So it can be revoked, it can be changed at any point prior to death. The testamentary capacity that I mentioned, we're going to presume that the person had the capacity to make changes throughout their life unless it can be proven otherwise. So, as someone becomes elderly, maybe they do become a little forgetful, but unless there is some sort of judicial proceeding where maybe a guardianship is placed over them, we're going to assume that, that they're able to make changes as they wish because it's their stuff. You can change your mind about how you want to deal with things. Probate is the process of dispensing of the decedent's estate and is managed under the supervision of a court. So, regardless of whether someone has a will or not, there is at least a minimal amount of probate that does need to be kind of gone through. The court just wants to make sure that the will is being followed as per the wishes and the statements made by the decedent. If no will exists, then the person who dies is referred to as dying intestate. And intestate distribution can vary from state to state, but a lot of times it follows this general pattern, so that whoever dies, if there is, obviously if there is, let's say, a spouse, we kind of look to see if there's a spouse involved. If there's no spouse, then we look down to like children, possibly grandchildren. If that doesn't exist, we look up and, like in the family tree, and we look at, are there parents that are still alive, one or both the parents. If that's not possible, then we kind of branch out into siblings, and that's usually like a formula that a lot of states seem to adhere to. The problem with dying intestate, so having no will, is that the property that gets distributed may not go to the parties or persons that you would like to see the property go to. So that's why it's important to draft a will. As life events occur, as changes occur, it is important to update your will as needed. For example, let's say you create a will when you're 30, and let's say you're single at the time, and fast forward it's to 40, 10 years goes by. You might be married by 40, you might have a couple of children, and so you're going to want to change your will. Wills can be kind of set aside for a couple of different reasons. One obviously is if there's a capacity issue. Another reason a will can be set aside is if you don't include all the possible heirs that you have. So, if you do have this will from, a decade ago or longer, but now you have children, and your will that that you created decades ago makes no mention of children because they weren't created yet. The will is going to most likely get set aside because you have to at least acknowledge that you have heirs. Once you acknowledge heirs, and I've seen this, I mean, I've helped people draft wills when I was practicing, and usually in a will, identify like, okay, I have 5 children, and then after they're all identified, do whatever you want with your property. You can give it equally to each child. You can give everything to one child. You can give nothing to any of them, and you can donate everything to a charity. It's your property. But as part of demonstrating capacity, we want to make sure you understand who the potential heirs are and at least acknowledge them in print, and then decide whatever you want to do with your property. I remember it's time goes by so fast. I remember it was 4 or 5 years ago when the musician Prince passed away, and to this day I still cannot believe that he died intestate without a will. I don't know if he just never got around to it, but the legal professionals around him should have certainly kind of urged him, and maybe they did, to enter into a will. Maybe he just didn't care, but when you accumulate things in your life, you want to make sure that it ends up going to the person or persons or entity that you would like to see your property go to. So usually the person who's making the will is called a testator. This is just some labels or terms. I'm just kind of quickly mention this. If it's a man, it's a testator. If it's a woman, it's a testatrix. The decedent, obviously, who dies with a valid will is said to have died testate. Remember, with no will, it's intestate. So just kind of like some of these terms as you read through this chapter. Property that's left to a person is a beneficiary, and it can be a person, it can be an organization or charity. You know, the will that I have property that is bequeathed to specific individuals, but then also I have property that's bequeathed to organizations, you know, that are charitable in nature. A legacy is referred to a gift of personal property. So maybe it's like an heirloom, could be a piece of jewelry. The gift of real property is referred to as a devise. And so, again, just these different terms that they get applied. Remember, for testamentary capacity, you just have to be able to kind of demonstrate that the will is effective upon death, and that you have an understanding of what you are conveying in that document upon death. And normally you do need to be at least 18 years old to create a will, and have this mental capacity. If it's ever revoked for some reason, so let's say someone is maybe institutionalized, if you are released, you know, and you know, I mean, so your mental capacity could be temporarily kind of like set aside, but you could have it resume. You know, if whatever you're impaired with is you know, you kind of get through that. I don't want to say cured, but you know, you're deemed to be, you know, fit to go back out into society. If it's because of some debilitating condition like dementia or Alzheimer's, heaven forbid, then you know, we're getting into other issues now where that's presumably going to be more permanent in nature, absent some sort of cure or treatment from the medical community. So it is also possible to have, like, you can just add on changes. So maybe the substance of your will is fine, but maybe you want to just kind of like, because you've acquired new property or maybe something has changed, you can do what's called a codicil. And so that's where you're just kind of, you know, just changing some minor things to the will. If you're doing a complete overhaul, in my opinion, I think it's best just to do a completely new will at that point. If you know, maybe you have new children, you know, maybe you can change who you want to devise things to, or bequeath, you know. So it depends on, you know, what we're referring to here. But you know, any kind of major change, I usually would encourage just, let's just kind of, you know, we can refer to the old will as we create a new one, and then we'll discard the old and go with the new then at that point, if there are substantive and major changes that have occurred. Special kinds of wills, there's something called a holographic will, where that's you know, that sounds kind of futuristic, but that's essentially, it's an unwitnessed will that's written entirely in the handwriting of the testator. Florida law does not recognize holographic wills. Other states do, but Florida does not. A self-proved will is the one that may be admitted to probate without the testimony of any type of witnesses. And then a living will is in regards to life-sustaining medical treatment procedures. So a lot of times, again, you know, attorneys, if you're doing a will, they'll encourage you to also do the living will, so that, you know, if you're involved in some sort of medical situation where you lose consciousness or the ability to make decisions, what would you like to have done? You know, do you want to be artificially hydrated, artificially fed, you know, kept alive through whatever means necessary, or not? And that's entirely up to you. You know, again, I know it's not a comfortable topic to talk about issues, you know, that are, you know, kind of like end of life issues. But again, you know, it's something that it's inevitable, you know, and it's important that, you know, however you think and reflect on these issues, it's critical that, you know, you make sure this is memorialized in writing, so that whatever your wishes are, you know, that they're going to be honored at that point. So probate, again, is that process by which a court reviews a will and ensures that everything is administered as per the terms of the will. Contest of a will, so that's where there is someone challenging the will. Some bases for that could be lack of mental capacity, and again, unless there's a presumption that you have capacity, unless it's been demonstrated otherwise previously. So that's not necessarily an easy hurdle to get over legally. Maybe you might argue that you know, the new beneficiary asserted undue influence, or maybe there was duress or fraud or forgery. There's a lot of different things that can possibly happen. I have a video link there, and I don't normally play video links, but if you're ever interested in seeing this, there was a documentary about an elderly couple, remarkable story, just a very sweet, adorable couple called Edith and Eddie. And it was a couple that they kind of connected with each other very late in life. And so, it involved, these end of life issues and the respective kind of like you know the perspectives of the families of Edith and Eddie. So if you have the time, you want to see the link there. It's just a video clip. The actual documentary, it's probably on Amazon or Netflix or some service. But it really is it's an interesting exploration of elderly issues, and how the law kind of intersects at those issue points. In terms of administration of estates, so the estate of a testator is going to be administered by a person usually referred to as an executor. Some states call it a personal representative. But that's the person who and trust that will honor and ensure that your last wishes are going to be taken care of. So it could be a spouse, it could be a child, it could be your family attorney, it could be a beloved friend. It's whoever you want to designate. It doesn't have to be any of those individuals. It can be who you want to select. Creditors, as they have claims against an estate, are required to give notice of their claims, and that usually is something that happens during that probate process. The only way a creditor is going to be able to recover any money is if there is property in the estate that's divisible or transferable. If someone dies and they essentially have nothing of value, they have no real property, you don't have cars, you don't have cash, you don't have stocks or bonds or investments, it's like, well, there's nothing really to recover then at that point. If you're a credit card company, or if you're if you have a personal loan that's owed, okay, sure, this person has died. They left behind furniture and some clothing and like personal knickknacks or whatever. The creditor is going to have to just charge that off as a loss. They cannot expect, family members to kind of pay the decedent's debt obligation. Debt does not transfer upon death. The only way that it possibly could is if it's a joint, like a marital debt. And so if a husband and wife, let's say they both have, community debt. If one dies, their surviving spouse, they're still obligated. But that's usually the only situation. Individualized debt normally dies with that person unless they have property in the estate to cover that. Linked with this, and we'll talk about in the next chapter a little bit about life insurance. Life insurance has nothing to do with a will, and it does not go through the will process. So, you may have, a house, cars, cash, all this stuff that's going to go through the will. Life insurance is an agreement where you have a third-party beneficiary arrangement, and so whoever the insurance company is, upon confirmation of your death, they will issue whatever the funds to the beneficiary you have noted in the life insurance policy. And it doesn't have to be your spouse. It doesn't have to be family members, children. Insurance policies are completely outside of the rules of the will-making process. Testate distribution of property. So just again, a few minor things, catch-all things near the end of this chapter. So residual legacies, that's where in the will it just says something like, I have, maybe a house, car, property. The house goes to so-and-so. The car goes to, someone else. And then everything else goes to George, or Susie. And so that would be like this. That would be a catch-all category. Instead of having to identify every specific thing, you could just say all household possessions, like furniture, clothing, whatever is, not, a fixture, that's attached to the real property. Some other issues that can arise if the beneficiary named in a will has died before the testator and there's no alternate provision. Then again, that's where we'll kind of look at the statutes and determine let's say a parent outlives their children, but in the will, the children are the ones who are supposed to get everything. A will can be forward-looking and say, look, if any of the beneficiaries have died, then it goes to their heirs. So that's one way to avoid this problem. But if you don't have that, then you have to refer to some other formula, and that would usually be the state statute that we just discussed a little while ago. If specifically bequeath property, so let's say I have a 57 Chevy, and I'm like, this goes to, Alicia, and I want to make sure she gets this car. if before I die I sell the car, or it's destroyed, or it just doesn't exist anymore, then, well, there's nothing to transfer at that point, and so that beneficiary that I designated for that specific piece of property is not going to get that property. They might get something else if they're mentioned elsewhere in the will, but that specific piece of property, since it doesn't exist anymore, I don't own it, then she would just be out then at that point. So if the decedent does not dispose of all the property by will or does not have a will, then, as I mentioned, we look at those intestacy statutes, and so again, just always understand the state has a formula that you may or may not agree with. So in terms of trusts, trust is a legal device by which property is held by one person for the benefit of another. So usually it's referred to as the settlor, but it's a property owner who creates the trust, and the person for who the benefit belongs to is the beneficiary. So it could be themselves, or it could be again, a charity, children, a spouse, whoever. There's usually two broad categories for trust. There's express and implied. Express would be like a testamentary trust, and that's usually where a will creates it. And so you have these inter vivos trusts, and that's created during the life of the grantor. So those are the types of express trusts that exist. Implied are where that's usually created by courts, so it could be a constructive trust if we're trying to prevent, let's say, unjust enrichment. That's something we covered in Business Law 1. And there's also something called resulting trusts that, again, the point is to carry out maybe the intent of the parties. So they can arise in one of those two situations, where it's express or it could be implied. So express is like more proactive, implied is more reactive. That's another way maybe to think of it. So usually the actual kind of like documentation that creates a trust is, not surprisingly, it's a trust agreement. It could be called a deed of trust. And there isn't necessarily a specific, form or language that's required. But a trust is not created unless there is an active duty that's placed on a trustee to manage that property. So you do have to have some person overseeing the trust so that, it's clear that this property is being managed in some way for whoever the identified beneficiary or beneficiaries are at that point. So in terms of title and interest in trust, so legal title to trust property is given to the trustee. So someone obviously that you believe is going to faithfully carry out their role as being the overseer or manager of your property. Equitable title, however, is held by whoever the beneficiary is. So even though legal title is given to this trustee, the equitable argument is that it's truly intended to benefit whoever the beneficiaries are, not to benefit the trustee. It's just the legal mechanism. We kind of have to parse that language out. A blind trust is when a grantor transfers assets, so that could be like stocks or bonds, to a trustee to manage them for the grantor. And I've seen this, usually this happens in cases where people want to avoid any kind of appearance of impropriety or bias. So I've known judges over the years that, when they become a judge, whether it's in the state or the federal system, they'll put their investments in a blind trust. So they have a financial manager who will, invest, their stocks, manage it. Maybe they'll buy and sell stocks, based on, market forecast and conditions. But the person, the beneficiary, the equitable owner, so to speak, they don't necessarily know, I don't know what stocks I have. Do I own Coca-Cola stock or Walt Disney stock or, Microsoft? I have no idea. And so, that's to kind of just, avoid any issue if a party comes before them in their courtroom that would have an issue with that. Sometimes lawmakers do the same thing. If you're, a governor, if you're the president, House, Senate member, you'll put all of your investments in a blind trust because you're going to most likely, either advocate, or try and pass legislation that maybe it might impact your investment. And if you know what your investments are, the temptation is there to potentially abuse that power. A charitable trust is where it's devoted, for any public purpose. It's very broad, so it could be political, it could be like social, environmental, disease-related, religious, it could be for the arts, any philanthropic endeavor. So that would be a charitable trust. If we're talking about a spendthrift trust, this is a special trust that's designed to protect beneficiaries from creditors. So there are some strategic advantages of kind of, dumping your property into a trust. So if you're trying to maybe minimize tax implications, or if you're trying to somehow, protect yourself from assets being taken from you, there are some limited abilities to do that. If you're the trustee, so if you're this, very trustworthy person, you're given a lot of power and discretion with regards to how this property is going to be managed and overseen. Everything is always going to be subject to, for lack of a better phrase, judicial review, meaning a court can kind of come in and just kind of monitor to make sure that these decisions are being made in a prudent way. So, you do normally have reasonable skill, in the performance of your duties. So, maybe you are a financial planner, maybe you're a CPA, maybe you're an attorney, and, you're acting as a trustee. There's some rational basis. You have some skills or qualifications. You have to invest trust property in a reasonable, prudent manner. And so, again, courts will understand that sometimes investments increase or decrease over time. But when you think of, like, very speculative or high risk investments, unless you're being directed by, the beneficiary or how the trust was set up, normally that's not something that a prudent investor would do. And definitely a huge thing is to keep accurate accounting records. Understand that everything that gets spent, any transfers that occur of property, has to be specifically documented. And so if you do not do that, even if you're otherwise faithfully carrying out your duties, you can get into a lot of trouble. Remedies, so there could be maybe a monetary judgment against the trustee. Injunction is just a legal term for kind of like preventing someone from doing something. Possible criminal prosecution, if there is a clear violation of a federal, state, or local ordinance or law. Recovery of property, removal of the trustee, recovery of any trust property from third parties who participated in the breach of trust. So maybe a trustee transferred property to a friend or a relative, and courts can reclaim that property or pull it back and put it back into the trust. So anyway, I hope this chapter gives you a little greater insight into the estate planning process. There's a lot of tools at your disposal, to kind of take care of all the property you acquire during your lifetime. And I cannot emphasize enough the need to properly, execute these documents so that whatever your wishes are, at key times in your life or at the end of your life, that all of the things that you've worked hard for get dealt with and dispensed as per your wishes. So anyway, kind of a serious topic, so I do apologize about that, but it's a fascinating area of the law. It's an area where it actually is a source of comfort. I just, on a personal note, during this whole pandemic, we all have kind of we've had to make decisions that are either minor or major in their importance. And for me, I decided to redo my will because I've had changes in my life over the years, and it's not an easy thing to do, but once you complete it, there is a sense of relief that it's like, okay, well, that's taken care of, and I don't have to worry about the what ifs. And so I know that the person I've designated is someone that I trust implicitly, and all the things that I've worked for, I know that they're going to see that it goes to whoever, or the entities involved, the charities involved, and I don't have to think about it. And so it's a great source of comfort if you can kind of look at it like that, even though it's tough. It was really tough, whenever you rehash all that stuff, you're thinking about you being gone, and it's a very difficult process. But anyway, sorry to get serious there, but anyway, do have a good, safe, and productive rest of your day and week, and I'll be chatting with you all online. Thank you so much.